What if the contract is silent on the delay analysis method? Which delay analysis method has to be selected? This is the most common doubts that arises when the contract is silent on the delay analysis methodology. Even high standard contracts like FIDIC, they don't mention any delay analysis methodologies. They only mention that the critical path affection has to be captured by the delay analysis method. So in that situations, there are contracts, bespoke contracts that mentions the delay analysis methodologies, which I have seen in my experience. Mostly they go with the TAA or IAP because they don't expect the disputes to happen after the end of the project, and they might ask for a retrospective analysis. Mostly, the objective of both the parties will be finding what is the completion date if the delay has occurred prospectively. So that's why most of the delay analysis methodology mentioned in the contracts will be prospective methodologies. So what is the first principle? The methodology must be fit for purpose. So when the contract does not prescribe a method, it shall reflect the contractual mechanism for UOT. It should be based on contemporaneous records. This is very, very important. It uses logic-linked CPM programs. The delay analyst or the planner who is making the delay analysis must be technically sound and transparent. And they have to assist the decision makers such as engineer, DAB, or tribunal. The objective is not to select a favorable method. So you should not select a method that gives you more advantage. It might be an engineer, or it might be a contractor, it might be an employee. You should take or select a methodology based on the first principle of fit for purpose. So coming to the industry question. So there are guidelines from SCL Delay and Disruption Protocol, edition 2017, which clearly clarifies how to select a methodology. It recommends that the methodology should be appropriate to the facts. The analysis should mirror how the delay occurred. Prospective analysis for ongoing project, retrospective analysis for completed projects. So some of the common methods, delay analysis methodologies it uses are impacted as planned, time impact analysis, as planned versus as built analysis, window analysis, collapsed as built analysis. The protocol emphasizes suitability over preferences. So what is the project status? That gives more importance for the choice of methodology on a very large overview or a bird eye. So it is usually two types, whether it's an ongoing project or completed project. An ongoing project, mostly we go with the prospective analysis. The most preferred prospective analysis is TAA, but most followed prospective analysis is IAP. The reason is TAA requires updated programs. It has to measure the prospective impact, and it aligns with the notice-based UOT mechanism. But most of the projects will not have the backups to a TAA. The difference between TAA and IAP is the updated programs. The updated programs is the one that gives the dynamic shift in the CPM. That is the critical path. So this approach is widely accepted in arbitration practices. So when coming to completed projects, either you may go with window analysis. Window analysis is nothing but the ABI analysis with more windows. As planned versus some as-built analysis and single window analysis, which is the most done analysis in arbitrations. Collapse as-built is very, very rare and controversial because collapse as-built is used when you don't have a baseline, but you have an as-built record or an as-built schedule, not as-built records, as-built schedule. So very rare projects don't have baseline, will have as-built schedule. The tribunals often prefer window analysis because it examines delay in chronological period, respects changes in critical paths, uses actual progress data. So legal position when the contract is silent is that the contractor cannot unilaterally impose a method, the employer cannot arbitrarily reject a single method. So what method best reflects the causation? Is the baseline program reliable? Does it have the integrity? or updates available, or records adequate to back up the delays. Does the method distort concurrency? So courts and tribunals focus on substance over label. So it is not about what the method is called, it's about whether it proves causation logically. That's what tribunals look for. The judicial and arbitral practices. International arbitral tribunals generally follow these principles. No method is inherently superior. The method must suit the available records. Poor records may limit the methodology. Artificial reconstruction is discouraged mostly. Critical path must be proven, not assumed. Even in contracts based on International Federation of FIDICs, tribunals do not automatically impose a TAE unless the contract requires prospective assessment. So what are the key technical factors that influence the selection? Quality of the baseline program is very important. Whether it is logic linked and it has the capacity to perform an analysis, because prospective analysis are mostly software driven. So if baseline's logics are not properly linked, and if you try to insert the delays, and the software may drive crazy if you don't have a proper logic link baseline. Availability of the updates, or monthly updates available, or quarterly updates available. Nature of the delays, single event or multiple intercepting delays or interacting delays. Concurrency issues, is true concurrency present? Concurrency is the most difficult part in proving in a delay analysis. Record integrity. So, are the site records and the backups that are used for the delay analysis are honest or reliable? And stage of the claim. So, at what stage the claim is going, whether it's a prospective or retrospective. So, a methodology inconsistent with these realities will fail under cross-examination. Common mistakes done during while the selection of methodologies is using IAP for a 5-year completed, but it is being done even today in industry. Mistake 2 is using a collapsed as-built without proving logic validity. Logic validity in the sense when you go for an as-built, logic linking is very difficult. So that's why this program is being mocked usually. Mistake 3 is ignoring the dynamic critical paths. Mistake 4, using insights to distort prospective entity. Mistake 5, choosing a method because it gives more delay days. Tribunals detect advocacy distinguished as analysis. So best practices is when the contract is silent, step 1, review the UOT class language carefully. Step 2, assess the program integrity. Step 3, identify the project status. Step 4, select methodology consistent with records. Step 5, explain why the method is appropriate. Transparency strengthens credibility. So what should be adapted? If it's an ongoing project, PAA. If it's a completed project with good updates, that means with good backup records, you can go with window analysis. Poor updates, but strong as-built data, you can go with as-planned versus as-built. Complex concurrency, then you should go for window analysis. So final thoughts are, when the contract is silent, delay methodology becomes a matter of technical integrity, evidentiary strength, legal perception. The winning analysis is not the most complex one. It is the one that mirrors the reality, proves the causation, survives cross-examination, assists the tribunal. So in delay disputes, methodology is not just a technical choice. It's a strategic decision because that will decide the winning to get the UOT, and your entire prolongation claim will be dependent on the UOT. So you have to understand how critical it is to select the methodology when you go for an UOT claim. Thanks for watching. Please comment if you want any other topics to be discussed. I get some LinkedIn DMs on specific topics. We are trying to make presentations out of it and trying to explain via videos. Thanks for watching. Take care. Bye.